Hi everyone, I'm Stuart Lawrence. I'm the founder of Mediator Locator. I'm a barrister, accredited mediator and adjudicator with more than 30 years of experience in dispute resolution. Today we're going to be talking about mediating contentious trusts and probate disputes. And as you might well imagine, these cases aren't just about money. They often involve deep family history, strong emotions and long-standing tensions. I'm delighted to be joined by three of the experts from our panel. Paul Lunt from Brabners Solicitors, Kay Baker from Ellisons Solicitors, and Tim Constable from Bates Wells Solicitors. So a real panel of experts. And maybe we can start by each of you introducing yourself a little more fully. So perhaps, Tim, if we start with you, if you can kick off by telling us about yourself, a little bit about your background and your experience in mediation.
Hello, I'm Tim Constable. I'm a partner in a commercial dispute resolution practice and also a contentious probate dispute resolution practice in the city called Bates Wells. I started as a paralegal in the 80s and worked in a one-man law firm, and then worked my way up to work in a very big international law firm before going to a slightly smaller city law firm where I'm currently based.
Wonderful. Thank you very much, Tim. Kay, maybe you can say a few words about your background.
Yes, I'm Kay Baker. I am head of Contentious Trusts and Probate and head of Court of Protection at Ellisons Solicitors. We're based in Essex and Suffolk, and we offer a full service of all areas of law in Essex and Suffolk.
Lovely. Thanks, Kay. And Paul, perhaps you could do a quick intro as well.
Hi, I'm Paul Lunt. I'm a partner and I'm head of the commercial litigation team in Brabners, the law firm, across all of the offices. We're a northern-based law firm with offices across Liverpool, Manchester, Leeds and Lancashire. I head up a team of over 60 lawyers, including a team of specialist contentious probate lawyers who do nothing else, and there's 6 of those in my team. For my sins, I get to supervise those amongst others. So I do a pretty broad range of work across my own practice. Most recently, more famous for the Agatha Christie trial, but I do an awful lot more normal stuff as well.
Excellent, thank you. And before we get into the questions, maybe Kay, would you just tell everybody what contentious trust and probate is? Because whilst the 4 of us understand it, there may be people listening who don't know. So maybe you can give a very quick summary of what it actually is we're talking about today.
Of course, yeah. It tends to be a dispute over a will, or the lack of a will, or a dispute over a trust. So a dispute over a will might be to do with its validity. Was it executed properly? Did the person know what they were doing when they signed it? Were they pressured into making the will? That kind of thing. Or it could be a claim for provision where someone's been left out of a will and feels they should have been reasonably provided for by that will or the lack of the will. And the trust dispute could be to do with the trustees not doing their job properly. It could be to do with the interpretation of the terms of a trust. I think, yeah, those are the main things.
Brilliant. That's wonderful. Thank you. That's great. So I'm going to move on to the questions that I have for you guys. And Paul, if I could start with you. The question is, why do contentious probate disputes feel so much more personal than other types of legal dispute? And how do you think that impacts on the mediation dynamic?
Yeah, it is a good question, because contentious probate disputes are far more personal in general terms. It is rare outside of there being charities involved and donations to charities. It's rare that you're dealing with large corporates and just numbers on a balance sheet. So it's, I think, probably essential to recognize that you're going to have to take a very different approach to what are real people, real life relationships, often over many years or decades of built up, whether it's built up love, hate, resentment, whatever it may be, that's the kind of mixed bag of human emotions you're going to have to realize is going to be involved, because there are very few of them, I think, that don't have any of those emotions. And it's not just the emotions and the relationships as between the litigants and the parties. I think depending on the timing, you have to recognize that it's often the case that a number and possibly all of the parties are still finding ways, and some of them struggling to grieve with the loss of a loved one, and that all of those emotions are bound up in the dispute. And I think it's because the emotions are running high that you feel that there may be difficulties in a mediation on contentious probate matters, because generally speaking, emotion in any dispute is a real barrier to settlement. It's certainly a barrier to kind of objective, reasoned, logical decision making, which is ultimately what mediation is trying to promote amongst the parties. So for me, in terms of trying to how to deal with that dynamic and the very personal nature of it, the pre-mediation for me is incredibly important. There's real benefit, I think, in spending time with the instructing solicitors for the parties to try and not only get to know from them the dynamic of the people involved and the dynamic as between the people involved, the dynamic of who may be likely to take the lead, but also to seek their views. I'm not saying you'd adopt their views, but it's always interesting to hear them as to what they think might work and might not work with certain individuals, and their take on what approach might work. And I think at the start of the mediation itself, outside of preparation, always with contentious probate mediations, I try and spend a bit more time with the parties themselves, often chatting about nothing to do with the dispute, just trying to get to know them, even ask them about their memories of the deceased or whatever that may be, even though that doesn't necessarily have any bearing on the dispute, but just to try and get to know them, win their trust and put them at ease. And I think that if you can make a good start at the outset of the mediation, it will pay dividends later on.
I suppose, just making them see that you're a human as well, and that it's not just about the resolution. You want to listen and understand and give them time to maybe to heal from what you're saying. Seems important.
Exactly, and it's essential because at some stage you're likely to be later on in the day trying to persuade them of the wisdom of settlement and why healing and so forth is actually something they should value greatly.
Yeah. No, that's really helpful. That's cool. Turning to you, Tim, what's your approach when one party sees the estate as justice for past family wrongs and another party maybe just wants to move on? How do you reconcile that sort of situation?
Yeah. That was very good what Paul said, and for me, this is all about family, and since everyone has got a family in some shape or form, anyone is going to be able to understand the two different positions if you look at it objectively. On the one hand, you're going to have the justice-seeking party. This party may have deep-seated historical grievances about being treated unfairly, particularly in what you get two types of cases quite often. You get cases involving siblings, brother v sister, that sort of idea. Then the other type of case is quite often where you get a step parent against the stepchildren. Those are pretty common examples. And on the one hand, you're going to have somebody with very deep-seated grievances, possibly fair, but nevertheless really deeply felt grievances, which go far beyond the will. And on the other hand, you're going to have the pragmatic party, so-called, somebody who just wants this off their desks, somebody who may actually agree with the person who's been aggrieved. But the fact is, there is a will, it is that person's will, and people will feel strongly that regardless of their own personal opinions, they have to see that will put into effect because it's none of their business. But nevertheless, if there is an accommodation to be reached, I would be looking at listening, as Paul said, absolutely. I'd be considering reframing the narrative. Is this about justice? Are we realistically going to get justice today, apart from listening? And are there other ways of looking at a successful day? Maybe the other side might like to listen. Certainly a conversation between the two parties must be a big aim of the thing. Reality testing, gently testing the expectations and trying to move on from the deep-seated feelings of a lack of justice to what we're actually going to have to be dealing with on the day. I'm interested in exploring interests and not just positions. What do people need? What can be done today that people can live with? And I would be looking and hoping that I'm fostering an atmosphere of empathy with both sides, because we all have families and we can all understand the positions that people were in. So that's a summary.
Yeah, no, that's really helpful. I mean, I think from both your answers to the first two questions, it's coming out that it's really very much emotion and understanding and empathy. So it kind of leads neatly on to the next question to Kay, which is when someone's grieving and they're angry, obviously very heightened emotions in these type of situations. As the mediator, how do you keep the mediation constructive without dismissing the emotional weight of the people involved?
I think there's a first question there, Stuart, before that question, which is, are feelings okay and our emotions okay in a mediation? And going back to what Paul was saying, lots of these people, the vast majority of people in a probate dispute won't have been in one before and won't have been to a mediation before. And I think what is important for them to know is that it's a long day and that feelings are allowed. And I actually think that's one of the benefits of mediation. You're in a room, you're in a private room, and you can let off as much steam as you like in that room. And that's probably part of what needs to be done. And you might even need to let off some of that steam to the mediator or explain your feelings to the mediator. But the benefit of mediation is you can do all that without it derailing settlement discussions. So you can let off some steam, you can tell everyone in your room how you're feeling, and then put some positive messaging back into the other room to keep things constructive. And I think that's the way forward. We're not telling people to be robots or superhuman. They can have their feelings. I'm sure their feelings are justified. And to be able to express them and have a mediator or their own lawyer understand and then be able to say, okay, yeah, that's for this room, but let's keep things moving forward with the other room and look at it commercially when going back to them.
Excellent. And kind of quick supplemental on that, how do you manage your own emotions? Because it's going to be pretty draining on the mediator as well. How do you cope when you're in these situations? Because you're seeing a lot of people probably at their most vulnerable. What sort of systems do you employ to keep yourself neutral, empathetic, but focus on the issues at hand?
Not just vulnerable, but not all these feelings are very nice feelings. And if I've just talked about letting off steam, or if you're constantly being let off steam if steam is being let off at you, that's not a very a nice thing over the course of a long day. And I think you've just got to take breaks and again keep moving things forward, knowing what your role is, which is a facilitator.
Yeah. Okay. Oh, that's brilliant. Thank you. Paul, got a quick fire one for you just to sort of speed up the dynamic on this one. What's the biggest myth about probate mediation, would you say?
Yeah, specific to probate mediation myths rather than other myths about mediation. I think there's a myth around everybody has to get in the same room, and that's not a great idea, where you've got often siblings, warring families. For some reason, I always find northern farming partnerships and families very challenging to try and actually referee, as it were, in that context. But as we know, in truth, mediation can be incredibly sensitive to whatever the dynamic of the parties, and you don't have to get in the same room or be on the same screen in an online mediation. And actually, it is even an opportunity for people to be heard in a controlled environment rather than around the kitchen table where everybody shouts at each other and there isn't any actually airing of opinions in any meaningful sense. But of course, ultimately, mediation is a far less adversarial and challenging forum than the alternative of court. So,
brilliant. Oh, that's great. Thanks. Jumping back to UK, how often do you think these mediations come down to a misunderstanding or lack of communication rather than a legal disagreement?
All the time. I think I don't know if it's a British thing, we're not that great about having difficult conversations with our families. We don't really like talking about what's in our wills. I think so many of the disputes wouldn't arise in the first place if parents sat down with their children and said, this is what we're doing in our wills and this is why. But of course, with that privacy can come secrecy. So then if what we see often is the will's changed at the last minute. Yeah. And one sibling doesn't know why, or what the circumstances were about that. So you go from privacy to secrecy, and then that's where the disputes.
Distrust, isn't it? Secrecy leads to distrust.
Yeah, I also think I've got a theory. We're not very empathetic when it comes to our siblings. I don't know if this is because Paul agrees with me.
We're all nodding.
I've got 3 brothers.
I don't know if maybe our emotional relationships and our emotional intelligence with our siblings stops at kind of adolescence or what, but I often see this where if it was anyone else, the person would be kinder and more empathetic, but when it's your sibling, you're so entrenched, and and the issues go back decades, and I don't think that helps at all. And absolute lack of communication, lack of ability to say I feel like this when you do this, which would help a lot, I think.
Yeah. Okay. No, that's great. Thanks. Tim, in your view, what does a successful outcome look like? Is it about money, or is there other things that perhaps mediation can do that other dispute resolution processes can't?
Well, successful mediation would be both sides signing on the dotted line of a settlement agreement. Most of the time it will be about money. The thing about money is that it is a very good method of enumerating a compromise between the people. So it's not just £0 or £100,000. It might be £50,000. It might be £250,000, and the figure will inevitably be a compromise figure, reflecting so much more than just the money. But obviously, it is about more than money. An ideal mediation success for me would be the chances are, by the time they've got to us mediators, there's been a legal dispute involving solicitors, and the chances are the family is not talking to one another, or certainly the protagonists in the mediation are not talking to one another. My hope would be that after the mediation is over, the family will at least have better family relations, such that they're talking with each other. That will be the dividend of peace, which extends far beyond any money, and it will extend for years.
Yeah, I mean I'm a massive fan of mediation across the board, particularly in this area. But I think we've talked before. Mediation's got so much more flexibility with outcomes. If you go to court in a contentious trust probate type situation like this, it's going to be a binary outcome. It's going to be down to money. Whereas I think what you've just said about the softer wins too, about maybe opening a dialogue with the family, makes, in my view, mediation a much better process, because it can do so much more than just give an outcome. If you go to court, you just get an outcome. Mediation, you can get an outcome and potentially a solution. So yeah, brilliant. Paul, coming back to yourself, trust disputes, as you'll be aware, can span generations and involve step families, business interests, and long-standing resentments. How do you untangle that sort of situation in a single day?
That can be a challenge, although personally I always have pre-mediation calls in advance of the day, because as ever, preparation is often key on these things. I think that the importance is to try to identify in advance and get in front of the issues as to what needs to be determined in order to reach a resolution, and who needs to make decisions on which issues to reach a resolution. Some parts of the issues that are presented in the papers don't necessarily need to form part of a mediated agreement at the end of it. And I think, again, if you can seek from all parties in advance and prep properly for what scope of decision making they envisage taking, and try and actually get everybody at least close to being on the same page before you start, then you can normally try to cut through what can often look like complex issues. But like every complex issue, it's just a series of smaller issues. And when you cut through it, often it's only 2 or 3 key things that you really need to happen, and decisions that need to be made to be able to reach a resolution.
So it's really getting the focus right at the outset, starting on the right path. Okay, no, that's really helpful. Jumping back to UK quick fire one. This is a more general question, but it relates to probate and trusts. What do you think is one thing that lawyers should stop doing in mediation? Obviously, parties may attend without lawyers, but if they do come with their lawyers, one thing that lawyers should stop doing. Any suggestions?
Come in without a draft agreement. I feel more strong about this as time goes on. Just before Christmas, I had a mediation that settled 8 p.m. and the drafting was finished at 2 a.m.
Oh, wow.
Yeah.
Wow.
And I think possibly people think it looks weak if they come with a draft agreement, because they want to be all blustery and we're probably never going to settle with you, coming in. So to then say you've got a draft agreement might make you look weak. I don't know, but if you can just have something, it's just saves time at the end when everyone's tired, just to have something to start working on.
Do you think there's a danger if, like in your situation, at 8 p.m. and then it took another sort of 6 hours? Do you think people might then think, well, let's reconvene tomorrow, or let's go now, draw up a quick heads of terms, and then we'll pick the agreement up subsequently? And there's potentially a real danger that that agreement starts to unravel. Do you think you have to kind of tie it off there and then, or does it not make much difference?
I think the bigger issue is that it's just not fair on anyone at that point. If during your working day as a lawyer you get a draft document to read, you go through it with a fine-tooth comb, and you're careful, and you might think on it, you might go away and come back the next day and look at it when you're fresh. To be asked to do that after a long day's mediation at 2 a.m. is just, I think it's a recipe for disaster, and it's just not fair on anyone.
Yeah, and when you say about the mediation agreement, obviously the mediator doesn't do the agreement, do they? It would be the solicitors representing the parties that start to draw up the agreement. That's accurate.
Yes.
Yeah. Okay, wonderful. Thank you. Jumping back to you, Paul. Next question. Have you ever had a party change their mind during the mediation because of something the other side said, not legally, but emotionally?
Yeah, the one that springs to mind was a family dispute in probate about who was going to continue running a large family business and who was doing what. And we thought we'd got to pretty much agreed terms. And one of the family siblings was outlining in plenary session, in a group session, how we thought everything had been agreed. But the way in which they chose to describe the role and the current existing job of one of their siblings caused enormous offence to that particular sibling, because they felt somewhat belittled and undermined by what was, I think, probably a rather too brief and summary description of what they actually did within the business. And they stood up and stormed out, and it took another hour to calm it all back down again. But it's one of the dangers we've all got to be constantly aware of when you get everybody in a room, or more than one party in a room.
So that's kind of a negative example. Can I press you maybe a positive example?
Yeah,
put you on the spot, haven't I?
There's plenty where you get tears. You get people talking again. I had 2 brothers who ran a scaffolding firm together and hadn't spoken for 20 years following the death of their dad. And they literally hadn't spoken, that their families didn't speak, or the nephews and nieces were ignored by the other half of the family. And happily now, it's 20 years on, I think, from best part of 20 years on, best of friends again, and working together again.
That's great. The power of mediation. That's really good. Tim, just a quick one-liner on this: in person or online for probate and contentious trusts?
Well, the first thing is, don't let it stop you mediating, whether it's got to be in person or online. Having said that, in person better, because you can convey far more of the humanity, far more of the empathy face to face in person rather than face to face on a screen. Face to face on a screen can still work, but it is better. It is better face. Sometimes practically it can't be done, but it's got to be in person. Yeah.
And I think, you know, on the mediation that we worked with you on, Kay, selecting a mediator, it was online, but that was due to specific circumstances because of the people involved. So I think I totally agree with what Tim said. I think that echoes what most people who are in this field say to me. So that's really helpful. Thanks.
I would say, Stuart, that that mediation worked well. My clients are very elderly.
Yeah.
I was in a room with them, a physical room, and mediator was on the screen, and it still worked very well. So it absolutely can be done.
Brilliant. No, that's great. Thank you. Kay, some people come to mediation thinking they're right and everyone else is unreasonable. What are your thoughts on that? How do you shift that mindset?
At risk of disagreeing with Tim, I try to remind people that it kind of is just about money, and your best result is the one where you leave with the most money in your pocket. So it's not about being right, it's not about winning, it's about looking at it as commercially as you can muster, and that's all the professionals can really deal with. It's great, you know. I had a mediation once where 2 of the 3 parties hugged at the end, and that's great. And obviously I've remembered that, so it's, you know, it did strike a chord. But
Yeah.
really we're here to settle a money dispute, and if you can encourage people to look at it commercially, and what unfortunately plays such a big part these days in trust and probate disputes is costs, and the recoverability or not of those costs. So you've got to, you know, say, do you want to pay them 20,000 or do you want to pay your lawyer 30,000, and you'll be a year down the line and you still won't have got anywhere. So it's to try and take out that win and lose, and to say, you know, how do I walk away with my shirt on my back, or you know with as much money in my pocket as I can. And I think, you know, just treat it as a commercial dispute. That's the way to do it.
Just to add to that as well, Kay, I mean, I totally agree with that. And one of the challenges I often find, and I find myself trying to impress upon people, is it is about money. It's about what you take away, not what somebody else gets as well. That's a common theme that
100%.
you know. But they're going to do. You know, as long as you're happy, I keep saying to them, don't worry about what everybody else is. You know, it's amazing how people focus on other people's position.
Yeah, I have this with my daughters. One will say, "Can I have a bag of crisps?" Because she had a bag of crisps, and I'll say, "Well, are you hungry?" It doesn't matter if you're not hungry. It doesn't matter what she had. Absolutely.
That's probably the toughest mediation role you play, isn't it?
Yeah.
Jumping back to you, Paul, a quick fire question. What do you think is the worst way to open a mediation session?
Yeah, well, if you have an opening plenary session where parties are involved and they fall apart, that's the worst one. I'll give you a very quick example. I did one where it involved 3 Samoan professional rugby league players who had formerly been really good friends, all came over to the UK to play rugby together, fell out over something I can't go into, and started speaking to each other in the plenary session in their native language. I didn't know what was said, but it resulted in 3 very big guys having a fight, so that was a challenge.
Wow. And you're still here to tell the tale.
I knew where the fire escape was.
Yeah, very wise. Kay, another question. What role does empathy play in building trust with participants who may not want to be in the room at all?
Yeah, I think it's really important, and appreciating that it's a much bigger day in their life than it is in your life. But I think not just empathy, but authenticity, just being human, showing that you're a human, and that you're interested in them, that you've read the papers, that you get it, you get where they're coming from. I think it's everything.
Yeah, brilliant. Tim, next one for your good self. A mediator sometimes underestimated in probate cases. Do you think it's sometimes seen as a tick box exercise rather than a key to resolution, particularly with the CPR rule changes that push people more towards mediation? Are you still seeing people see it as a tick box exercise?
Well, I don't know about other. I think people who have got less experience of mediation will tend to think of it more as a tick box exercise. But if you've been around the block in terms of mediation, as we have, you can see that it will settle. It can settle virtually anything. I always say that people need to. The statistics don't lie. Over 90% of all mediation. So this is a CEDA, Centre of Dispute Resolution survey, which they do every year. And
the
over
competition, 90... Tim?
Well,
the competition.
But over 90% of all mediations result in a successful conclusion, either on the day or shortly thereafter. You just look at that figure, 90% success rate, as opposed to a court case. You know, would even the successful victor these days regard themselves as being wholly successful, given the massive amount of costs that they may have gone to achieve there, which some of which or all of which may be irrecoverable. And you know, say for example, I'm asked to give a prospects of success on a litigation at the start of it, even if I thought that somebody had a very good chance of success. There's always litigation risk, and litigation risk is, you know, it's normally 70-30 on a good case, 70% chances of success. That means even on the best possible case, there's a 30% chance that somebody's not going to win that case. I mean, that's just gambling. That's and it's only 20% off flipping a coin in terms of 50-50 prospects. And you get that, and then, but what we can offer is certainty, and as I mentioned, the peace dividend. Imagine waking up tomorrow with this dispute behind you, and we've seen it happen, and that is what makes me think that it's so much more than box ticking. Yeah,
no, that's great. Thank you. Couple more questions. Paul, do you ever sense that parties are clinging to the dispute because it's a last connection to their loved one, you know, the deceased in that case, and how do you address that?
Yeah, I mean that does arise, and it's not that unusual, but actually it's not always in the way that you imagine. I find the most difficult thing where they're clinging it's not the attachment to the deceased necessarily. They cling to the litigation, that they want to prolong the litigation because that is giving them still a level of connection, a forum, and whether for whatever purpose it might be to lord it over their siblings or whatever it may be. But it's not uncommon that you find people who are they've become engrossed in the litigation itself, and that's the real challenge to unravel. How you do it, I mean, generally speaking, the approach is to just, in a granular sense, break it down and walk them through what not settling looks like in all of its gory detail, and walk them through the process, and then try and actually just get them to just sit you often one-on-one. I mean, sometimes I'll try and actually just sit with a party, just me and them, as it were, to do that and actually just bring some reality to it and get rid of that kind of wholly illogical clinging to the litigation itself.
Yeah. No, that's great. That's really helpful. Kay, jumping back to you, when we have mediation and you have the solicitors in attendance, how can mediators support solicitors during the process without stepping on their toes regarding advocacy and advice?
This isn't easy. I'm not saying this is easy to do, but if there are some very obvious red lines, being able to communicate those early on is really useful. If I give an example, I had a dispute where one of the issues was who were going to be the trustees going forward, and I was acting for one of the parties on that day. I was acting for the young adult who didn't want these people to be her trustees anymore, and the mediator said, "Okay, we're not going to change that today. They're insistent they should be the trustees. You know, if that's not going to work for your client, then we probably need to go home." But it enabled us to work with that. You know, we could assess that, decide how we felt about that, and accept it in this case, and look at the substantive, more important matters, and just accept that they were going to be the trustees moving forward, because we decided we were happy with that. I also really appreciate, as a solicitor, I really appreciate a mediator telling me early on if it's going nowhere, and this has happened to me as well. I don't think there is a lot of mediation for the sake of ticking boxes these days. I think in itself it's a financial commitment for parties. So I don't think that's the case, like it maybe possibly is in divorce, I might guess. But I have had cases where it's just going nowhere. And you know, if you can really, as a mediator, really see it's going nowhere and draw a line under things, you know, everyone can get their evening back. And as a solicitor, that's really worthwhile to me to know I can get my evening back rather than flogging a dead horse. So those two things, they're both difficult, as I say, you know, because a red line is a red line until someone rubs it out, I guess. But if you can really clearly see, you know, these are not arguments that we're going to be able to move on with today. Can we focus on these ones? Best to know early. And if it's not going anywhere.
That's kind of helpful as well, because even if the mediation doesn't resolve the dispute, it can really narrow the issues. So I suppose people sometimes think, you know, if the mediation doesn't settle everything, it's not been successful. But of course, in many cases, you might resolve an awful lot of issues without necessarily resolving everything. But you've narrowed the scope of the dispute, and that's going to save people a lot of time and money going forward, which I think is perhaps an important point.
Stuart, also, at least the parties have been able to be in one building for one day trying to settle it.
Yeah, perfect. Actually, it's fortuitous, Tim, because the next question comes to you, and just a couple more. What should clients look for when choosing a mediator for trust and probate disputes? And do you think having a specialist experience in this area matters?
Well, they always say that a plumber could settle a rocket fuel dispute, or you know, something like that. It should not need experience in the probate probate itself. Having said that, I think experience of what can happen in a probate action can pay huge dividends, because if you have an experienced mediator in the practice, then that can often be half the battle, certainly in terms of empathy and moving things along.
I mean, I guess that makes sense, doesn't it? You know, if you've got someone that understands, particularly if the parties aren't represented, someone that understands the legal framework well, and they start doing the reality testing, on the mediator does the reality testing, they can perhaps, you know, make it clear to parties when they're taking a position that's entirely unreasonable.
Yeah, well, especially if the parties are unrepresented. I couldn't agree with you. You would need an experienced practitioner, a mediator.
Okay. Couple more. Paul, last one for you. Quick fire question. How long should a good probate mediation take?
Yeah, I mean, it's tempting to say as long as it takes, but actually, I'm not sure that's
probably the answer, isn't it?
It's not necessarily helpful, because, I mean, I wasn't a probate mediation, but I did a mediation when I represented the Commonwealth Games Federation suing the Australian government for pulling out of the hosting of 2026 games, and we'd set aside over a week for the mediation. But I'm not sure you want to encourage people to take longer than is necessary, if you see what I mean. And equally, I know one solicitor who favours having half-day mediations and always having them on a Friday afternoon, because his theory is everyone will be desperate to get to the bar, the pub, the home, whatever, by 5 p.m. on a Friday, and it constitutes the exercise. But I'm not so sure that either of those two extremes is the right answer. I think one day is always a good target time. Just keeping the momentum going is the key thing.
So next time I put you forward for a mediation and ask for your availability, and I get 4 Fridays in a row, I'll know exactly what your game is.
You know my plan.
Yeah, absolutely. Kay, last one for you. Just a quick one. One thing you wish more families understood before walking into a mediation?
That the mediator isn't a judge. I have this a lot, you know, make sure you tell the mediator this, you know, make sure the mediator needs to know this, has the mediator seen this? And the mediator is not going to make a judgment call on any of it. It doesn't even matter if the mediator thinks you've got a really good case. That's, you know, that shouldn't be where your focus is.
Yeah, excellent. And final word, Tim, to your good self. What do you think are the main risks of not mediating, especially when families jump straight into the litigation process?
You'd be completely bonkers to jump straight into litigation is even more bonkers. At the very least, you should go through the pre-action protocol and exchange letters, because at least then you can actually understand the case which each person has to meet. Then after that, if you are given a realistic appraisal of the county court system, which is underfunded, all the roofs are leaking, and they'll lose your file, etc., etc. And in the High Court, which is probably the best justice you'll find in the world, but it's also the most expensive justice you'll find in the world, where you are in the gambling den. As I say, it would be bonkers not to consider mediation early on.
Brilliant. Well, that's been really, really helpful, and thank you all of you for your expertise and insight. I think my big takeaway, and it's a message that I love, is if you don't mediate, you're bonkers, because I believe it totally. I think, you'd be crazy not to mediate. And so many respects, there's not an awful lot to lose if you mediate and it doesn't work, because it's still really cheap compared to the alternatives and quick. So thank you, everyone. That brings us to the end of today's discussion on contentious trusts and probate. A huge thank you goes out to Paul, Kay and Tim for sharing their insight and their expertise. And all that remains to say is thank you for joining us. And if you'd like to learn more about mediation, or if you'd like to connect with one of our first-class mediators, please get in touch with us at mediatorlocator.com. We'd be delighted to help you. Thank you very much. Thank you very much, everyone, and goodbye for now.
Thank you.